and welcome to a very special episode of The Presumption. I'm here with my partner in crime, Jim Griffin, and with our lovely producer, Matt Fondelier. Hi, guys. How are you?
Hey, Sarah. Good. How are you doing?
Good, good. It's hot as hell in my office. We don't have AC on holidays. And I know, Jim, you have been working around the clock. You know, Matt, he's been coming up on all these episodes, sitting there all coy and quiet. And he's just been up to like really good trouble, apparently, right?
It's like a good poker player, you know, you don't want to show all the cards.
Right.
We've been very busy, and thank you, Matt, for coming in on Labor Day at the late hour that it is. And
and
important things to discuss.
Yeah, so it's important because tomorrow, September 5th, 2023, Jim and his defense team on the Alex Murdaugh case are filing a very important motion. It's a motion to stay the appeal with an underlying motion for a new trial based on newly discovered evidence. And boy, oh boy, it could not be more shocking what you guys have uncovered. So before we launch into what we're going to discuss, and I have so many questions for you, Jim, you know, when the verdict came in March, I think it was March 5th. So, you know, I don't know if y'all timed this so perfectly, but literally what a difference 6 months makes. Because on that day, I was so upset by this travesty. And you and I were, DMing each other on Twitter and messaging and stuff. And I did this thread that I wanted Matt to put, there's some pieces of it that we highlighted that really pertain to, where you're headed with this motion. So in the first part of the thread, I say all these various reasons that I think that you guys can appeal or attack the conviction. And one of them highlighted there is jury misconduct. Although we're not going to be really talking about jury misconduct, we are talking about a big jury issue in your motion. And then I went on to say, when the jurors began deliberating, 3 swayed from unanimity. Sorry, I don't have my glasses today. 2 were for not guilty and 1 undecided. Yet in less than an hour, the jury reached a unanimous verdict. There are also reports that some jurors may have been impaneled despite views against the presumption of innocence. And then keep going, Matt. Yeah, and then there's like 2 more pieces to this thread, kind of relevant to what we're talking about. Murdaugh's counsel will do a thorough investigation into any potential jury misconduct, and then we need to know more about possible jury misconduct. Now, you know, I know I was saying jury misconduct because that's typically what we call it, but the motion that Jim is filing tomorrow pertains to outside influence with the jury. Either way, it's a jury issue. And I also wanted to play a clip of Jim on this Fox Nation piece that was just dropped earlier this week. Jim mentioned something interesting about jurors at the end of a trial when they deliberate and they come back with a verdict. So let's play that.
Have you reached a verdict?
Yes, sir, we have.
When you have a favorable verdict, jurors sometimes will smile at you, nod at you. So we had an early verdict come back, and we had no one looking at us.
Right.
That's a bad sign. That's a bad sign.
That's a bad sign. I know. And you were so upset. And I remember saying, I remember talking to Jim and saying, please go on the Cuomo show on News Nation. And Jim just felt so defeated. And I know that feeling so well. And I had to remind him that this was not a trial that he lost. It was the trial where it was essentially scripted and, lined up to lose. And then the last piece of clip I think that's relevant to Jim's filing is from the Fox Nation piece showing the clerk of the court speaking.
Madam Clerk, you may publish the verdict.
I'm the one that read the verdict of Alex Murdaugh. And I was a little, my breath was knocked out for a moment. But then I have to tell myself to treat this just like any other trial, any other verdict that I have to read. And I have to place my mind there and take out any other personal relationships.
Yeah, Felicia. Show did. All right. Well, let's talk about this, Jim. So you have filed this motion, or you're going to be filing this motion tomorrow. And it is huge. And just in full disclosure, I have not read it. I don't have a copy of it. It's not public yet, but you've been generous enough on this platform for us to do this, to share the details and the arguments and the law that supports your motion. So I really want you to flesh out for us, what are you arguing in this motion, and what is this newly discovered evidence that you are presenting to the court?
Sure, Sarah. And just to be clear, we're not dropping this podcast until after the motion is filed, and we're scheduled to have a press conference tomorrow at 2:30, and we expect a full crowd and a lot of interest, because what we have learned since the trial and interviewing jurors, and frankly, let me begin like this. Immediately after the jury verdict came back so quickly, we had received, and I don't want to give up my sources, but we had received information that something untoward or amiss had occurred, and we didn't know what it was. But we were not going to let it go, and we continued to press. But up until Becky Hill's released a book about behind the scenes of justice.
Becky Hill is the clerk of the court.
The clerk of court. Yeah. Up until the date she released that book, there had been, camaraderie amongst the jurors, a zone of silence, but when she released the book, was profiting off of the trial, that zone of silence cracked, and we have received a flood of information that, frankly, is jaw-dropping. When I heard it from the first juror, I shook my head and then could not believe it. And it is this, Sarah. During the course of the trial, juries are sequestered. When I say sequestered, I mean they're in a separate room from everyone else, and they're not supposed to be talking amongst themselves about the testimony, not supposed to be talking amongst themselves about the evidence, and clearly aren't supposed to be talking to third parties about the evidence. And what 3 jurors have reported to us is that right before the defense, that means Dick Harpootlian, me, Phil Barber, Maggie Fox, had started to put up our defense, Becky Hill, the clerk of court, goes into the jury room and speaks to a number of the jurors and says, essentially, don't be misled by the evidence that Alex Murdaugh's lawyers are going to put before you. Now, this is an officer of the court. This is an officer of the court talking to the jurors, telling them the defense is about to mislead you, and don't fall for it. And then you get to the point of the trial where Alex Murdaugh is testifying, intends to take the stand in his own defense. And again, she goes into the jury room before they hear the testimony and says, don't be fooled by his testimony. Watch his body language. Be careful. And we have affidavits from jurors that are on file. We've kept their identity anonymous. We filed and we referred to their juror numbers. But they took it to mean that Ms. Hill and the court, because she's an extension of the court, believed that Alex was guilty, and that the defense was trying to pull a fast one on them. And then beyond that, we have learned from the jurors' interviews and supported by sworn testimony that we filed, that right before deliberation, Ms. Hill tells the jury, this should not take you long. This should not take you long. And then she says, but if you are here by 11 o'clock, you're all going to be put up in a hotel and sequestered. No one was prepared to spend the night. But to make matters worse, there were 6 smokers on the jury. And they asked for a smoke break. And guess what? They were told, no, you cannot go on a smoke break. Although they've been taking smoke breaks during the entire trial, you cannot go on a smoke break until you reach a verdict. And
well, didn't she also say to them that if you take too long, we're going to have to like essentially sequester you and have
well,
you
that's
stay.
right. That's what I said. You have to spend the night in the hotel. Yeah.
Right. And so that's like no jury wants that, obviously.
And
Yeah.
stop. There's more. You would not believe. There's more. There's one juror that the court had gotten some information from an email that maybe she had talked to a third party about her assessment of the evidence at some point in stage in the trial. You've read or heard, and most people know about, the court conducted an in-camera investigation. We have now learned a couple of things. That juror who was actually removed after my closing argument and before the jury began deliberating, up until she was removed and she was, quote, under investigation, Becky Hill, the clerk of court, was questioning her as to whether she believed Alec was guilty or innocent. And she's an active juror on the case.
Unbelievable.
And this juror told Becky Hill that I've not made up my mind yet. And then she goes further and she says, well, what makes you think he might be guilty? And she says, well, the dog kennel video. Well, what makes you think he might be innocent? And she says, well, there are no murder weapons. Not finding any murder weapons. And then, I don't have it right in front of me, but Ms. Hill says something to the effect, you shouldn't worry about the murder weapons. The Murdaughs got rid of those guns. You'll never find them. This is an extension of the court.
Is this woman, is she going to lose her?
There's more, Matt. There's
oh
more.
My God.
And so the question is whether this juror who has expressed, independence and frankly, this juror that we're talking about, it was no secret to everybody in the courtroom that she smiled at us. She smiled at Alec. She didn't smile at the prosecution. And if you had to label her during the trial, she was a defense juror. And during this whole issue of whether she's going to be removed, the clerk of court comes up and presents a false narrative about some Facebook post that her ex-husband allegedly posted that said that the same juror got drunk talking with her after getting drunk and expressing her opinion on Alec's guilt or innocence. And she confronted the juror about that. Well, a couple of things. One, that Facebook post was never made by anybody. And we have since, there's evidence. It's kind of complicated. I'm not going to get too weedy here, and people will be able to read the filing. But we have pretty clear proof that evidence is pretty uncontradicted that Ms. Hill knew, or certainly should have known, that there was no such post. But she goes beyond that, and she says that SLED went out and confirmed with her husband, ex-husband, that he put the post up. And beyond that, she says at one point in time, her ex-husband, he's hearing all this stuff. He calls her. She freaks out, goes to Ms. Hill and says, now my ex-husband actually is calling me. And Becky Hill says to this juror, the Murdaughs got to him. And while she is still on the jury, now she was ultimately removed, and we're going to have to explore, just how much information was relayed to whom and those things. But we have
basically to sum this up, this particular evidence that you got from this juror, Becky Hill orchestrated a Facebook post that had not been made, and orchestrated these facts to sort of push her off the jury, right?
That's certainly what it looks like. Yes.
Right. And this was the one, because remember everyone, it takes one juror,
right?
To hang the jury. It takes one juror. So one matters. There's more. There's more. On this guy? On this lady?
No, not on this lady, but
hold on. I have questions on this lady, Jeff. Hold on a second. Wasn't it this lady that you said, she was asked which way you're leaning and stuff like that. But didn't this lady also say to you guys that Becky Hill, I'm sorry, that two jurors would go into the bathroom regularly together and discuss the case?
Yeah. So, and she said that, and the jurors are not supposed to be talking about the case. And two of the jurors would go in to, a separate room or bathroom and would speak about the case. But beyond that, I mean, there's evidence that Becky Hill would go into a bathroom with the forelady of the jury, who and frequently and spend 5 and 10 minutes in there with her, and then would tell the other jurors, don't ask her what we talked about. Now, we don't know what they talked about, but we know that she was in the bathroom talking to this juror, and this juror was, we've now since learned she was very pro-prosecution. And you may recall during the trial, the jury elected their own foreperson. Mm-hmm. And we now know that foreperson was one of the ones that was undecided on guilt, even at the end of the case. After all the lobbying that we've now learned took place in the jury room by the clerk of court, that juror was removed and replaced by this person who was pro-prosecution, who spent a lot of time with Miss Hill in the bathroom. And when they visited the Moselle property, Miss Hill and this juror, according to the statements that we have from other jurors, walked the property together. And then Miss Hill in her book says, after the Moselle sightseeing, we knew he was guilty.
Oh my God!
Who's the we? Who is the we? It is the most astonishing thing I've ever experienced in my
totally 30 jaw-dropping. Yeah, and I love the word choice in your motion that you just read to me. I don't have a copy of it, but where you said, and then the jury got a court-appointed foreperson. Court-appointed, like a court-appointed attorney.
And you might remember, or it's hard to know what actually gets broadcasted during the trial, but the jurors wrote a note complaining to the judge. Said, I thought we picked the foreperson, and the judge says nope. And so there was a switch. So you hear the
now we're going into another one.
When you hear the excitement, the agitation in my voice. So the statements about Miss Hill saying, and I'm not, these are not verbatim, but in summary, be careful about the defense case. They're going to distract you and watch it carefully. Yeah. So we have two other jurors who have given us the same statement. So independently, I mean, these people are met independently, and
they corroborate each other
1,000%. Okay. And what we've also learned is the jury. So there, and we're going to hear, some jurors say, I never heard this. And what we learned during our investigation is that what we learned during the investigation is that the jurors had two rooms, and I don't know if they were adjoining or not, but because we had 16 jurors, including alternates, that they added additional space, and so most of the guys were in one room, and most of the women were in another room, and these conversations that have been reported to us, where Miss Hill is instructing the jurors on how to assess the evidence and of that nature, were mostly done in the room where forelady was and other women jurors. Now we have gotten, we interviewed one of the male jurors who says that he recalled Miss Hill telling him or people in his room, that you're going to see some disturbing evidence, and it's autopsy photos, and try not to let it bother you. Now that was pretty innocuous, but she has no business. Talking to the jurors about any of the evidence. And I'll tell you one other thing, Matt. During the in-camera hearings with Judge Newman,
I feel like I'm on the Price is Right Showcase Showdown, but it like a much darker version. There's more. Oh God!
Oh yeah, and there's more. And during the in-camera hearing, about this jurors, whether she spoke out of school as to her, assessment of the evidence at some point in time during the trial. And this Facebook post comes up that I'm talking to you about. And the juror says to Judge Newman, Ms. Becky, told me about this Facebook post. And we're all sort of flummoxed that that Becky Hill is talking to the juror about, these issues. The juror is excused, and Judge Newman basically says to the prosecutor and me that he's shocked that she would be questioning the juror instead of bringing the information to him. And that's in the record. And I said, I'm extremely surprised, Your Honor. And, but what we know now is that was the tip of the iceberg. That was the tip of the iceberg.
Well, and then, I think it's also timing is everything. And I think one thing our listeners and viewers need to remember is that Becky Hill had a book deal in place while all this was happening. So it's not like the trial ended and then she started shopping around her book. This lady knew that she's going to be selling a book. And
And we've got one of the jurors told us that she's handing out media cards. She's encouraged them, to give interviews. And anybody in the courtroom noticed that on the day of my closing argument, which was, I think it was March 3rd, Sarah, is when the jury came back with a verdict.
Okay.
I think March 2nd. I'm sorry, March 2nd. But
okay.
Jurors who've been wearing pretty casual clothes the whole time are coming in suits, dressed in their Sunday finest.
I remember people that were in the courtroom. I was texting different people, Avery Wilkes, and I can't remember who else it was, but I was in, you obviously, and I think it was Avery who said, it's really weird. They're all dressed in suits today and they're all dressed up. And I said, what? Like how? I mean, okay, maybe they're just dressing up for deliberations. But it was just it was a fact that stood out to everybody that was in that courtroom. So one thing that's interesting, Jim, is there some sort of an internal investigation that the county's going to do on her for her to lose her job? I mean, that's the first thing, right? But there's bigger things for you. But I just want to know what will happen to her. I'm sure she's lawyered up. I'm sure this is not a good weekend for her.
Well, we haven't filed this information publicly, so I don't know what she's done. It will be public come tomorrow.
And it'll be investigated
on September the 5th. As soon as the filing is returned and we get filed copies, we have a letter we're hand delivering to the U.S. Attorney asking for a federal investigation into whether there's criminal conduct related to the deprivation of Alex's civil rights, and did it involve and we did the conduct of Ms. Hill as stated by the jurors in their sworn affidavit rise to that level, and was anyone else involved? And we're going to ask SLED to stand down because SLED's got a vested interest in upholding this conviction, and we're asking the FBI to get involved and do an investigation. Now, what other ramifications will be, I don't know, but I can't.
But explain the FBI. Okay, so the federal investigation of outside influence on this jury, what relief do you get from that? So in other words, if the feds come in and they realize that this was, is that just in lieu of SLED doing it, or that's a separate civil rights violation that you would pursue?
No, at this point, Sarah, we just want it fully investigated. The questions we have are, did it go beyond the clerk of court, right? Is the clerk of court working in conjunction with some other state actors? And if so, who are they state actors? Are they law enforcement?
And that includes potentially, I'm not accusing anybody yet, but that a state actor would also be Judge Newman, right?
He would be a state actor. I'm not here alleging any misconduct on behalf of Judge Newman. I think,
no, me neither.
And Sarah, I got to tell you, I was in the conference room with him when he learned that she was questioning this juror about a Facebook post. and he was genuinely surprised, and I was genuinely surprised. So I don't think for one second that Judge Newman knew that Becky Hill was doing the things that these jurors say she was doing. But who is she reporting to? And you know, I don't know. I don't know. And so if she's a solo actor and if she's doing it, you know, maliciously, or is she doing it, you know, just because she doesn't know any better, and she just let the moment, you know, the spotlight blinded her. You know, part of our podcast here is, you know, the effect of media on high profile trials, and that may be all we have here is that you know, she just wanted her 15 minutes of fame, and a hung jury wouldn't have gotten that for her. You know, acquittal probably would not have gotten that for her. But are there more things at play here? I mean, that's what the federal.
But I think it's really important, because I can just hear people coming on Twitter tomorrow with their, you know, the minions of the other camp and all that. You know, she doesn't have to be a nefarious person to have done these things, to have violated the law and violated Alex Murdaugh's right to a fair and impartial jury and a fair trial. It could be exactly like what you said, that she just wanted, you know, how often does Colleton County get, you know, a high profile case like this with all of these, media outlets there and the world watching. So, you know, I can see how my point, I guess, is it doesn't have to be nefarious for you to get the relief that the law, allows you to. So, and that's the next thing I was going to talk about is that.
And that, I mean, that's why we want an investigation. I will tell you, we have looked into what training clerk of courts receive, and Ms. Hill was elected, you know, maybe 2 years ago. So this is her first term, and she's, you know, the Colleton County clerk of court. But her prior experience is she was a court reporter, meaning she typed down what people said, but that was as far as, and so she did have courtroom experience, but there's really no formal training in South Carolina on training what court reporters are supposed to do. Now, there should be mandatory training, but and so is it just?
That's very interesting that she never went through any formal training to be a clerk.
No, there's no requirement. The only requirement is you get more votes than the next person. I mean, I
get that, but the problem is that you
don't have to be a lawyer.
I understand that.
I can be a clerk. I can just move to South Carolina and be like, it's clerk time, baby.
Yeah, but isn't there an orientation that says, yo, you can't go into rooms with specific, you know, just single out jurors and take them to a room. You can't, you know, have conversations. I mean, there's no orientation.
My understanding is there's not. I mean, there's a magistrates get, you know, appointed or elected, and they're required to go to, you know, school, but there's no such school for clerk of courts. That's crazy. What we learned. And so, you know, is this just incompetent? But you know, we don't know the answer. We don't know the answer to that, but we certainly don't believe SLED would give us the answer, and we certainly don't believe the Colleton County Sheriff's Department would give us the answer.
Of course not. And I think you're doing the right thing, but I think that my problem is, and I'm sure, like I said, she has counsel. She's going to deny this stuff. It's very difficult, I think, to get around 3 different people essentially mirroring each other's affidavits or sworn testimony. So my point is that she may have done it innocently, but she has still violated Alex Murdaugh's constitutional rights.
Yeah, and so I guess let's don't get crossways here. That's a whole separate issue. Is, you know, you ask what's going to happen to her. What's going to happen to Alex? So here's what we know the law is. The law is if there's outside contact with a jury during the case, it's considered prejudicial, and the state has to then come forward and prove it's harmless. And there are a lot of cases where, you know.
Well, wait a second. it's called a Reamer hearing. It's a Supreme Court case. And the defense, your burden is not beyond a reasonable doubt. It's by preponderance of the evidence. And I think you've absolutely done that here, Jim. I think you have met your burden. So then the burden then shifts to the state of South Carolina to show that it was harmless. Okay.
Yeah. And so I did get ahead of myself. So these affidavits that we filed in court today, when you hear this podcast, we are asking the Court of Appeals, because the jurisdiction of the case now is in the Court of Appeals. We're asking the Court of Appeals to hold our appeal on abeyance, remand the case for limited purpose for an evidentiary hearing, a Reamer hearing. And that Reamer, REMMER, is Reamer versus United States. It's a federal constitutional case from the U.S. Supreme Court in 1954 that says, where there's evidence of outside influence upon a jury, and if there is, that would deprive a defendant of his constitutional right to trial by jury, and as guaranteed by 14th Amendment, 6th Amendment, 5th Amendment, all the amendments, frankly. But and so at that hearing, if we come forward and prove by preponderance of the evidence that they've had this improper contact, as these jurors said existed, and here, because it was a court official, it was a public official. It wasn't just, a litigant or a witness or, a spectator who said something to the jury. This was a court official. And the law presumes that is prejudicial, and that the state has to come forward and overcome that with evidence that the subject matter of the communication was clearly harmless. And here, the subject matter of the communication,
no way they can do that.
Credibility of the testimony of the defendant and the credibility of the defense case.
Right.
And in my view, there's no way in the world that a court could say that's clearly harmless.
Yeah.
Clearly
it's material. Harmless. It's not harmless. It's material.
It goes to the heart of the case.
Yeah, it's the heart of the case.
When a defendant testifies, and Lord knows we had enough at stake putting Alec on the stand and doing a calculus as to pros and cons, and we certainly didn't think one of the cons would be that the clerk of court was in there, according to the testimony of these jurors, saying, "Don't believe this guy. Watch his body language." And so,
well, and didn't Judge Newman? This kind of brings me to my next issue that I want to address with you, Jim. But didn't Judge Newman say that you got the right verdict and the evidence points to the right conclusion?
Sure.
How does that play into what you're describing as the harmless error analysis?
Well, yeah. So it goes to the point I just made is the subject matter of the communication harmless, clearly harmless, not whether in the judge's view did the jury get the right result, because if that's the test, then there would, as long as the judge thinks you got the right result, there'd be no analysis whatsoever. Right. You could stick a gun to 12 jurors and say, you find him guilty. Mm-hmm. They find him guilty. And, the judge said, I know he's guilty. So, we do address that in our brief. We think that, the law is, we just think it's solid. The facts are solid. And we feel very good about, our ability to get a new trial. If we don't get it here, we will get it one day. I mean, so the avenues are, go before the trial judge, have this hearing. If that's denied, wrap it up on appeal. If that's denied in the South Carolina Court of Appeals, then we move over to federal courts. And I've been doing this a long time, and I've taken cases from the state to the federal courts, and similar kind of,
issues
and an unsavory client, and gotten full relief in federal court. I don't think that, I have high confidence in Judge Newman. I have high confidence in our judiciary at the appellate level. And so,
but let me ask you something.
Apply the law to the facts, we get a new trial. See you in Walter.
Okay. So before you even get a new trial, and where that trial is going to go, which judge is going to preside over that trial. I personally, given not just, and I'm going to say this because I'm not in South Carolina. I don't think in this lifetime I will ever appear before Judge Newman. So I'm fine. I think that given not only the questionable floodgate that he opened up on all the financial evidence, that is also obviously part of your appeal, he also made some inappropriate comments, and by going and doing an interview on the Today Show, I mean, there is no question that he should not be the person to hear a motion for a new trial, whether to grant that or not, let alone a new trial if it's granted. So at what point, and I know this is a matter of strategy, do you think you guys will consider, or at what point would you even start, the analysis of, do you want to recuse this judge if he does not recuse himself?
Sarah, I'm not going to deny that we've had those conversations, but frankly, the time to make that decision is when the Court of Appeals remands the case for an evidentiary hearing. And we're dealing with a calendar here. And I mean, Judge Newman's last day on the bench, as I understand it, is December 31st, 2023.
Oh, he's retiring.
Well, he's reaching mandatory retirement age at age of 72. And so he will no longer be a judge. And he's told us as much, that, he says, y'all are all talking about doing something in 2024. And he says, I'm out of here at the end of 2023. So it may be that's not an option, for any, we don't have to make that decision.
What do you think is the timeline? I mean, you guys are like, you move at snail pace is what I've learned. Because like you still don't have your appellate record, and it's like, 6 months later. So I have to ask, when do you expect having a potentially a date for this evidentiary hearing, and when do you think that would be?
Oh, good grief. I mean, I don't know. I mean, I can't even ballpark it. It depends a lot on whether the state concedes our right to have a Reamer hearing, and they do not contest it in the Court of Appeals. If they contest us in the Court of Appeals, then they have 14 or 30 days. I think they have 30 days to respond to our motion, and we have 14 days to reply, and then the court will then decide it, or will the Supreme Court take it up? Will there be argument in the appellate courts on it? I mean, all that could take to the end of the year if the state doesn't agree to remand for a Reamer hearing. But if they agree, if they agree to remand for a Reamer hearing, I think we could very well be in court before the end of the year. So I do not know the answer to that.
Well, I am coming to Colleton County.
If we have it here, yeah. So
I remember when Jim's he was doing his closing argument, and I had nerded out so much on this trial that there was me and another lawyer out of Santa Barbara who sort of met on Twitter because of our similar like-minded analysis, and we literally started writing our own closing argument for this case, because we had live tweeted this fucking trial for months or whatever, weeks, and so by then I'd connected with Jim, and I was just like, "Are you saying this?" I was like, I kept throwing him sound bites. Like, "Can you say this? Can you put this in your closing argument?" Like, this guy's gonna kill me. Like, if I was doing a closing argument and someone was constantly sending me fodder, I'd be like, "Just shut up," But he was always,
you don't talk to a pitcher in the middle of trying to throw a no hitter.
Exactly, but he's always good to us, so he entertained it. But anyway, this is really, really huge, and like you said, it's astonishing. And I knew that there's something wrong, and I knew that one day we would uncover things. You guys would uncover things, and I just didn't think. I didn't think we'd do it at like the 6-month mark. Frankly, it is. I'm just thrilled for you and your team to have to have gotten people that are cooperative, that were able to, come forward with the truth. And I just think it's solid, Jim. I mean, I think that you had a really good, it's an uphill battle, an appeal. It's an uphill battle, but this is a whole other level. And so I really wish you guys a lot of luck.
Let me throw one thing out here. This piece really, the person who should get 99% of the credit is Dick Harpootlian. He is, he's so intuitive about these things. We got this info, very, sketchy info, and he has been on it like a dog on a bone, and he has been relentless, and people just don't know how hard he's worked. And word was up that, his black Mercedes has been driving around Colleton County for quite some time. And we've been down some dirt roads and trailers and
I mean, he's so tenacious. He's so tenacious. And I'm traveling, I'll say, Dick, I'm going here this weekend. That's all right. I'll go. I'll take Holly with me. And so, I mean, they were doing these affidavits in, I just can't tell you the environment. It's what lawyers do. And we have no, we're not billing by the hour. We're not collecting a check, You're in the red. You're in the red, Bo. You're in the red, but
we do not quit. Churchill said in the commencement, I told Dick this today. I said, you may want to use this line from Churchill's commencement address. I think it was Oxford School or something. He says, and during World War II, Churchill says his entire commencement address, never give up, never give in. And then Dick says, he was drunk. So, anyway.
But, I was having this conversation with Will Folks today, because he was talking about his podcast, etc. And I was singing your praises, which, I'm no nonsense. I don't do that unless I really believe it. And I was also saying that you guys work perfectly together. Like, you're very different. And that was so visible to me during the trial. Dick is sort of this debonair, and he's really is a state senator. And, and Jim's like the relatable street guy. And it was so interesting to watch, because I could just see how, I've done a lot of trials with other lawyers, and it really works nicely when you're in synergy and you each add something that's really different, and you have your fortes and all that. And so you guys really work like perfectly together that way. You're different, but you're just as, you're the spunky one. He's the more cool and collected one. You get more trouble. He doesn't get as much trouble, at least not, in front of the cameras, but you're just tenacious, and it's so lovely to see, because that, like you said, that is what we do. If you can't do that, if you're in this job for the money, you're not going to be good at it, because often the pay is not good. And even in private practice, I think there's a myth that somehow we're richer, or, we're rolling in dough. And no, we end up we walk into a case, and, you and I will talk about this on another episode in more detail, but, sometimes we walk in a case and we believe in the cause so much that we just charge a fraction of what we would normally, what our hourly is worth. Right. And sometimes the money runs out. We don't just walk out. We fight till the end. So it's so nice to see that happening. And I hope that your client is very grateful to you, Jim.
He is. If I ever get to talk to him again, I'm sure he will express his gratitude.
Those things will soften up, but I wore red lipstick for Big Red.
There you go. Big Red did review the affidavits. He's a lawyer, and he was flabbergasted. And then right before I left the prison, he said, "Please tell Dick thank you to everybody." He was very grateful. So this is. I was on Chris Cuomo's show, and I said,
last week,
this is unprecedented. And
it is.
It is unprecedented.
It is like everything about this case, just before we sign off, is like a film. I mean, I know there's been a lot of documentaries and films made on it, but the way that it played out is like, oh my God. It's like the day that you were feeling the loss of the battle and you didn't want to go on Cuomo. We were having this conversation. It's like, I mean, everything from the way that the misinformation was spread into the community, that you couldn't get a fair jury. And then now what we learned about the clerk of the court influencing the jury, the rulings of the judge. I'm sorry, but he did carry water for the prosecution 1,000%. And then all of it was just, and then the bomb scare that you had one day. I mean, it's crazy. But it all, to me, when you stand back and look at it as an observer, it looks like one big orchestration, by different parties,
Well,
somebody had different pieces,
There's the final chapter has not been written on this case. Nope. And now this is a whole new chapter before we ever get to the final chapter. So
yeah. Yeah.
I mean, you guys could not have picked a better time to start doing this podcast as well. I mean, this is literally like the theory of this show being played out in public. So it's not something we necessarily planned, but I feel like there's really not a better example of kind of breaking down the issue with a problem like this than we've already been doing for the last, 4 months on the show.
By the way, I just want to say this because we've never said this before and viewers always want to kind of hear the BTS. The way that this podcast came about, I really believe that when things fall into place very organically, naturally, and you're not fighting for it and you're not hustling for it, that it's meant to be. And the timing of how I connected with Jim, how we were just having this conversation about our frustrations about the issues and the mission of this, ultimately what became the mission of this podcast. And then, how we found you, Matt, I mean, you really were the first candidate that we interviewed. And I was like, we love Matt. I mean, and Jim was like, yeah, we love Matt, I mean, everything. And then the graphics, like everything was like it just like fell into place. And so
hang on. No, Sarah and Matt said, we need some theme music. And I said, well, I have a client whose son is
that's right,
musician in Nashville. He writes music. Reached out to Caleb Fletcher, and he says, we told him what we're up to. He gave us the first, sound.
That's right. We loved it. Loved it.
I'm not going to tell the world what Caleb charges because he would go broke if people try to get that. But, he's a family friend, and Caleb Fletcher loved the music. Now, I don't know.
Yeah, and then we loved his music. We didn't really have to go back and forth with that. One of my really good high school friends has an ad agency who ended up doing the graphics, and they were so spot on with the vision that we really didn't have to make a lot of tweaks and stuff to that. Everything just fell into place. And so I'm grateful to you guys. And I'm looking forward to doing it a little differently at CrimeCon. But we'll talk about that on a different day. Jim and I are going to do a powwow later this week, right, Jim?
Yep. I got a few things going on. I got to the Today Show to do. I got Chris Cuomo to do.
When is the Today Show?
Wednesday morning, I've been told. They've asked us 8:00 Wednesday morning.
By remote?
Yeah, we'll be at the ETV studio here in Columbia. Yep.
That's anchoring or interviewing?
No one's told me. I was prepping for this, but it'd probably be Craig Melvin. He's from Columbia.
Oh yeah, Craig Melvin. That's right.
He's a friend.
Yeah. Well, no, you and I can do it on Friday. We'll talk. Don't worry about it. All right, you guys. Thank you so much. We did not take an ad break.
Oh, we took an ad break.
Oh, we did.
Yeah, I'll put an ad in there.
We need
to shout out. It's a good time to shout out. We are on a new platform, Spreaker. So if you want to subscribe to our show, you could do it through all the normal platforms, but you could also subscribe to us through Spreaker, which is a podcast platform as well. Check us out on YouTube, youtube.com/@thepresumption. Follow us on Twitter, Instagram. As Jim and Sarah indicated, we got a lot of great stuff coming for you guys. So love the support. thank you guys all so much. And
Thank you. And we'll
Sara,
see you
Jim,
next time.
We are restless, but we're going to rest.
We rest. See ya.